The Ministry of Home Affairs has cancelled the Foreign Contribution Regulation Act or the FCRA license of Rajiv Gandhi Foundation and Rajiv Gandhi Charitable Trust organizations associated with the Gandhi family for alleged violations of the law. In 2020, the central government had set up an interministerial committee to coordinate investigations into the funding of the three trusts linked to the Nehru Gandhi family, the RGF, RGCT and the Indira Gandhi Memorial Trust. The BJP has alleged at the time that the RGF had received funds from China to conduct studies that are not in interest of the country, alongside investigations into the violation of various legal provisions of PMLA or the Prevention of Money Laundering Act, Income Tax Act, FCRA, etc. were to be conducted as well. So now, what is FCRA? The Foreign Contribution Regulation Act or the FCRA was enacted during the emergency in 1976 amid apprehensions that foreign powers were interfering in India's affairs by pumping money into the country through independent organizations. These concerns were in fact even older. They had been expressed in Parliament as early as 1969. The law sought to regulate foreign donations to individuals and associations so that they functioned in a manner consistent with the values of a sovereign democratic republic. An amended FCRA was enacted under the UPA government in 2010 to consolidate the law on utilization of foreign funds and to prohibit their use for any activities detrimental to national interest. The law was amended again by the current government in 2020, giving the government tighter control and scrutiny over the receipt and utilization of foreign funds by NGOs. Broadly, the FCRA requires every person or NGO seeking to receive foreign donations to be registered under the Act, to open a bank account for the receipt of the foreign funds in State Bank of India, Delhi, and to utilize those funds only for the purpose for which they have been received and as stipulated in the Act. They are also required to file annual returns and they must not transfer the funds to another NGO. The Act prohibits the receipt of foreign funds by candidates for elections, journalists or newspaper and media broadcast companies, judges and government servants, members of legislature and political parties or their office bearers and organizations of a political nature. In the first week of July this year, the MHA effected changes to FCRA rules through 2 Gazette notifications and increased the number of compoundable offences under the Act from 7 to 12. The other key changes were exemption from intimation to the government for contributions less than Rs 10 lakh. The earlier limit was Rs 1 lakh received from relatives abroad, and increase in time limit for intimation of opening of bank accounts. Under the new rules, political parties, legislature members, election candidates, judges, government servants, journalists and media houses among others, all barred from receiving foreign contributions, will no longer be prosecuted if they receive foreign contribution from relatives abroad and fail to intimate the government within 90 days. However, the recipient will be required to pay 5% of the foreign contribution received. How is FCRA granted? NGOs that want to receive foreign funds must apply online in a prescribed format with the required documentation. FCRA registrations are granted to individuals or associations that have definite cultural, economic, educational, religious and social programs. Following the application by the NGO, the MHA makes inquiries through the Intelligence Bureau into the antecedents of the applicant and accordingly processes the application. Under the FCRA, the applicant should not be fictitious or benami and should not have been prosecuted or convicted for indulging in activities aimed at conversion through inducement of force, either directly or indirectly from one religious faith to another. The applicant also should not have been prosecuted for or convicted of creating communal tension or disharmony, should not have been found guilty of diversion or misutilization of funds, and should not be engaged or likely to be engaged in the propagation of sedition. The MHA is required to approve or reject the application within 90 days. In case of failure to process the application in the given time, the MHA is expected to inform the NGO for the reasons of the same. The FCRA registration of close to 5,900 NGOs, including Oxfam India Trust and Indian Medical Association, lapsed on December 31st last year. According to sources, the registration of as many as 5,789 NGOs have lapsed after they have failed to apply for renewal before the due date. The rest of who had applied for renewal were refused as the MHA found their operations or accounts to be in violations of the FCRA, sources had said that time. According to the MHA, NGOs failing to apply before the due date can petition the ministry with cogent reasons within 4 months of the expiry of registration, following which their applications can be reconsidered. Many NGOs do not apply for renewal for a variety of reasons, which include either completion of the project for which the FCRA registration had been taken or the NGO itself folding up. Now let's try to understand who cannot receive foreign donations. Members of the legislature and political parties, government officials, judges and media persons are prohibited from receiving any foreign contribution. However, in 2017, the MHA through the Finance Bill route amended the 1976 repealed FCRA law, paving the way for political parties to receive funds from the Indian subsidiary of a foreign company or a foreign company in which an Indian holds 50% or more shares. The amendment, according to legal experts, followed accusations that the Bharatiya Janata Party and Congress have been receiving foreign funds for political activities from the UK-based Vedanta Group from 2004 to 2012. The Association for Democratic Reforms, ADR, a public advocacy group, had filed a public interest litigation petition at the Delhi High Court in 2013 against both parties for violating FCRA norms by accepting foreign funds. Both parties challenged a High Court order which had termed the donations illegal in 2014 and moved the Supreme Court. They withdrew the petitions after the FCRA was amended retrospectively. Cancellation of approval. The government reserves the right to cancel the FCRA registration of any NGO if it finds it to be in violation of the Act. Registration can be cancelled if an inquiry finds a false statement in the application, if the NGO is found to have violated any of the terms or conditions of the certificate or renewal, if it has not been engaged in any reasonable activity in its chosen field for the benefit of the society for 2 consecutive years, or if it has become defunct. Registrations are also cancelled when an audit finds irregularities in the finances of an NGO in terms of misutilization of foreign funds. According to FCRA, no order of cancellation of certificate can be made unless the person or NGO concerned has been given a reasonable opportunity of being heard. Once the registration of an NGO is cancelled, it is not eligible for re-registration for 3 years. The ministry also has powers to suspend the NGO's registration for 180 days pending inquiry and can freeze its funds. All orders of the government can be challenged in the High Court. NGOs accused of violating FCRA provisions. Several international and well-known NGOs such as Compassion International, Greenpeace India, Sabrang Trust, Lawyers Collective, Amnesty International and Ford Foundation have come under the government's scanner for alleged violations of FCRA. Most have been accused of financial irregularities or political activity for cancellation of their registration. According to the Ministry of Home Affairs data, since 2011, the registration of 20,664 associations was cancelled for violations such as misutilization of foreign contribution, non-submission of mandatory annual returns, and diversion of foreign funds for other purposes. As of September 11, there are 49,843 FCRA registered associations. So now, what if the license is suspended? The MHA can temporarily revoke an association's FCRA registration after inspecting its books and obtaining any negative feedback about its operations. Until a decision is made, the association is unable to accept new donations or use more than 25% of the funds in the designated bank account without approval from the MHA. The MHA has the authority to cancel an organization's registration, after which it will be ineligible for registration or granting of prior authorization for 3 years. When an audit uncovers problems in an NGO's finances such as misappropriation of foreign cash, registrations are also revoked. According to the FCRA, no certificate cancellation order can be granted until the person or the NGO in question has a reasonable opportunity to be heard. An NGO's registration is cancelled after 3 years and it is not eligible for re-registration.